I'm going to provide a bit of background as to the two key developments that we're really wanting to assess today, and to touch a few notes on really how we think additional, I guess, advocacy can be done on this point. So, as I mentioned, I'm Rights and Security International's UK Accountability Officer, leading our UK-wide work stream with a particular focus on human rights in Northern Ireland. We also want to say thank you to the New York City Bar Association for co-convening this event with Rights and Security International, with particular thanks to the International Human Rights Committee, the Council on International Affairs and European Affairs Committee. I want to start off by explaining the particular importance of human rights in Northern Ireland, something that Rights and Security International has addressed on many occasions in its submissions to the UK government on its proposed legislative reforms. I will keep this brief because I know these issues will be discussed in more detail by the other speakers, and I suspect also in the Q&A at the end. So of course, human rights are important to every region in the UK, but changes to laws will have a particular impact on Northern Ireland as these norms are central to the Belfast Good Friday Agreement. This agreement is not only a peace agreement, but has also been described as a constitutional instrument for Northern Ireland. For instance, by Lord Bingham in the 2002 case of Robinson against the Secretary of State for Northern Ireland, which was before the UK House of Lords. So this agreement, among other things, creates an international obligation to ensure that the European Convention on Human Rights is incorporated into Northern Ireland law, with access to the courts and remedies available for when the convention is breached. Under law across the UK, the ECHR is the only international human rights instrument which remains directly enforceable before the UK courts. For instance, there's no equivalent to the International Covenant on Civil and Political Rights or any of the other human rights treaties. I think it was summed up well before the court. So in the 2015 application by the Human Rights Commission, when it was said by the High Court that in Northern Ireland, the Good Friday Agreement was built on foundations, one of which was the guarantee of rights, safeguards, and equality of opportunity. So I wanted to start off with that today to illustrate almost the importance of the rights discourse. The first of two matters that we're going to address in this seminar is the proposed legislation to, and I quote directly from the UK government here, address the legacy of the conflict in Northern Ireland. Last month, the UK government announced draft legislation to this effect, entitled the Northern Ireland Troubles Legacy and Reconciliation Bill. This was following the release of a much criticised command paper in July 2021. Following extensive and almost universal backlash to its original proposals for a range of reasons, the UK government has said that it has since engaged with relevant stakeholders, although it appears that any such consultations may have had limited impact on the drafting of the bill currently working its way through Parliament. I will briefly outline these proposals in a few words to kick off the conversation. There are many issues that can be discussed, for instance, with the independence of the proposed bodies and the procedures, compliance with human rights laws, victims and survivors' rights, and efficacy, among others. But I will leave the discussion and analysis to the rest of our speakers. So this legislation plans to do three things primarily. So firstly, it will create a independent commission for reconciliation and information recovery, which is intended to review information related to conflict-related deaths and other serious conflict-related crimes. Secondly, it will plan to create a so-called conditional immunity program, which will set a low bar for people seeking to provide information about events that they witnessed or participated in, with the promise of a minimal review of their actions and no criminal or civil punishment as a result. Finally, the legislation plans to create an oral history and memorialization program, which will generate an official history of the Troubles. It is worthwhile noting at this early stage that many cases remain unresolved, and hence this is why we are still talking about them, whereas domestic and international courts have frequently found the UK government to be in breach of its human rights obligations to effectively investigate conflict-related deaths and other serious human rights concerns. So as a starting point, I think it's important to view those legislative proposals in that lens. The second matter that we're going to be talking about in a bit more detail later is the proposed reforms to the Human Rights Act and the creation of a new Bill of Rights across the UK. For those of you that are unaware, it is the Human Rights Act, which incorporates the European Convention on Human Rights into UK law, and therefore which provides the access to the courts and access to a remedy that is mandated by the Belfast Good Friday Agreement. At present, we are awaiting the UK government's final proposals in the form of draft legislation. However, many of the proposals are currently clear, and it appears somewhat unlikely that we will see significant changes when the draft legislation is announced. The UK government's plans to amend this vital human rights framework will likely have severe implications for the peace agreement in Northern Ireland, which we discuss later on in more detail. To list some of the key proposals, it appears likely that there will be a less influential role for the European Court of Human Rights, which is the Strasbourg court, which monitors compliance with the ECHR and has pronounced on an array of cases of pertinence in Northern Ireland, including those related to the Troubles. It appears as if there will also be a rebalancing of certain rights, so that some rights are seen as hierarchically superior to others. There will be the creation of additional stages within court processes, which will make legal proceedings regarding human rights claims more onerous, both in terms of logistics and finances for claimants with legitimate claims. There will likely be a reduction in the remedies available to a claimant based on their prior conduct. And it also appears that Parliament's trying to create a greater role for itself in the human rights process while taking a bit away from the courts. So before passing on to the other speakers who will no doubt address these issues in further detail, I wanted to explain briefly what I think needs to be done. Of course, based on my brief critique and our extensive work on each of these topics over the last few years, we believe that both pieces of planned legislation must be stopped. However, doing so may prove difficult in practice with a Conservative Party with a considerable majority. A great effort really is needed to achieve that objective. One way to do so, and one of the reasons why we're holding this event, is because one of the primary means is through international pressure, particularly from the United States. So advocacy and input from the US is so important in present times, what with the impact of Brexit and particular importance of trade deals for the UK government. In practice, this current UK government appears more willing to engage with those audiences than with civil society organizations who focus more on human rights. However, it's promising to see so many attendees today from so many locations and backgrounds who are interested in this topic. I do believe that there are ways to stop this retrogression of human rights protections in Northern Ireland. So as we approach the UK's fourth annual Universal Periodic Review before the UN Human Rights Infrastructure later this year, I think there's even greater opportunity for international scrutiny of the UK's human rights practice, particularly as this relates to Northern Ireland. So that's it from me. Thanks all for listening. I will now hand over to, sorry, I forget who's second. So yeah, I'll now hand over to Brian, who's going to speak in more detail about the planned legacy legislation.
Well, hello, and thanks very much for inviting me to talk to you today. Oddly, I'm actually in New York, and it's a shame that this isn't an in-person meeting, but you know, those days are coming back slowly. So I work for Human Rights First, and we have for 40 years, I would say, been engaged with issues, human rights issues in the north of Ireland. We used to be called the Lawyers Committee for Human Rights, and much of our culture is still focused on both in the US, north of Ireland, in other countries that we work on law and legal protections, human rights protections, and usually pretty specifically in the sort of work I do on trying to protect human rights lawyers. Of course, back in the late 80s and 90s, when the human rights lawyers Pat Finucane and Rosemary Nelson were murdered, our organization did a fair amount there in terms of research and advocacy about that. And in more recent times, I've also produced some research on the vilification and the online smearing and threats against human rights lawyers in the north of Ireland. And they've really been targeted mostly at those lawyers who are trying to find justice through whatever mechanisms there currently exist for those legacy cases. Although then more recently, as all of you are probably aware, Colin Harvey, the legal academic based at Queen's University in Belfast, who doesn't deal, he doesn't deal with his casework of the legacy issues, but he was subjected to a horrific campaign of vilification online. And so they're the sorts of issues that we generally cover. So the legacy proposals are important in our work because they affect the ability of human rights defenders, human rights lawyers in the north of Ireland to do their jobs properly. And no disrespect to all those massively huge and sophisticated legal minds on this call. I'm certainly not one of those. But the test for me really in these proposals is, what do the victims groups think? Because frankly, if they thought it was a good idea, I wouldn't really mind about the legal thresholds. I just wouldn't. If the victims and survivors are satisfied, that's sort of all right for me. But clearly they're not, right? And so that's the test here with these proposals, which offer a path, looks to me like a fairly easy path to immunity from prosecution from perpetrators. Clearly the survivors, the victims groups are very unhappy about that, as they should be. And so that's why they're a bad idea, these proposals. I have to say, I see little appetite among the British public, in fact, little knowledge base among the British public on these issues. I mean, there are exceptions, of course, but for most voters in England, Scotland and Wales, these issues just really don't register, I would say, on the top 50 or possibly 100 things they're worried about. In as much as, they might relate to a sort of a Brexit hangover, very simplistic, where does this lead us back to a conflict or not? But I mean, as we've seen with many of the other overrides that the present British government has made on international treaties and international law, the public really haven't been much of a counterweight to that. Even those who really could hold the government to account, as in Conservative supporters, they're just not doing that. So then I think, we're looking at who else could possibly delay or amend or even stop this legislation. I think one thing that was quite heartening was, that this is the second version of this legislation. It's a bit less worse than the original command paper. And there really was a pretty coordinated pushback from various groups, really, all the groups that mattered from the north of Ireland, the NGOs, the human rights lawyers, the victims, survivors groups of various different flavors. So I think that that's useful. And if we can get that sort of consensus again to push back, it might make the British government rethink a bit. The other big player here, I think it's right to say that the US still does matter. I think the US influence in other parts of the world is mattering less and less in terms of its soft power. But here I think it still matters. The British government still does get rattled when either members of the administration or members of Congress speak out about this, and there's the semi-veiled threat around the terms of a new trade deal with Britain. So I think that's worth pushing, and I do think there's a lot of mileage in there actually in trying to amend or cut or smooth off some of the rougher edges of this, but it's not really redeemable. I mean, you can't just cut out a couple of paragraphs in this legislation and it's sort of all right. Totally personally speaking, and I may well be like a minority of one on this, I don't think it's outlandish to think that there will be a British general election soon. The Prime Minister survived a vote of no confidence, but an awful lot of his MPs voted against him. sort of about 150 voted against him of his own party, and about 250 voted for him. I suspect that either he will go, or that they will keep him on long enough to try to see if he can swing another electoral victory for them. Anyway, all this means, I think, that this legislation may not go through in this current parliament. And so I think that a good tactic is to try and delay this thing, because it might be delayed to death, depending on the outcome of the next election. So in terms of what we can do about it, I think there are three things. I mean, I think we should take it as given that it's awful and we should try and stop it. I don't think that I want to spend much time on saying why it's so awful. I'm sure, either you already know or the other speakers are going to address that. But the 3 points really are locally, as in if we can get that consensus again across civil society, across politics, and across the public in the North of Ireland to really push back that this isn't the solution that they're after. That matters. I think that US government pressure also matters. And I think that anything we can do to try and delay this legislation really might, if we're lucky, pay off and see the death of it. I think I'll leave it there for now. I'm absolutely happy to answer, any of the questions you have. The last thing I'd say is, of course, it's the government's job, or government's plural job, to hold perpetrators to account, and in a sense to reveal and find the truth. But when they're not doing that, there are plenty other initiatives underway to uncover the truth. I mean, there's an academic side of it, there's a journalistic side of it. In the mechanisms which so far still exist, initiatives like the coroner's inquiry that we saw into the Ballymurphy massacre really managed to produce an awful lot of factual truth which had hitherto been hidden and would be closed down under these new legislations. For our part at Human Rights First, we've developed a tech search engine, which we're working with the Pat Finucane Centre on, which really combs through recently declassified British government documents related to the conflict. There are about 500,000 pages there, and we think that there's some interesting, perhaps, in fact, certainly revelatory stuff there, but finding it is really very difficult, right? I mean, these are typewritten pages from the 70s, 80s and 90s. So we've just finished producing like a magic search machine, basically, where you can put in the name of a person or an incident or a regiment or a location, and it will give you across this 500,000 documents what the search engine finds. So we hope that it will help victims and survivors groups to get a little bit closer to the truth. But really, this is a huge, large-scale project, and the government needs to undertake it properly, and it's showing no signs of that. And just as importantly, it needs to hold the perpetrators to account, and it seems to be doing everything to wriggle out of doing that. And thanks very much again.
Thanks, Brian. That was a very interesting talk, and thanks for being so open and honest about your perspective on this. We're going to pass over next to Aoife O'Donoghue, who's going to speak a bit more about the other aspect of the retrogression of human rights protections in Northern Ireland as the subject of this webinar, and that's the impact of potential reforms to the Human Rights Act. So I'll hand over to you.
Thanks, Jacob, and thanks very much to Rights and Security International and to the New York City Bar. I'm really delighted to be here and to talk about this, because I do think it's extremely important, and it's been rumbling on for a long time. I wrote a paper about earlier iterations of these reforms several years ago now as part of a project, a Forming Identities project with several others, and I could say it's improved since then, because originally they were calling it the British Bill of Rights, and they cotton on that maybe that mightn't be a great name for something of this nature. So we've got onto the modern Bill of Rights, but it has a very specific impact on Northern Ireland, that while the most recent paper that the government produced and the consultation that was released mentions the devolved regions and mentions Northern Ireland, really doesn't go anywhere near addressing the issues that it raises. And one of the key things I wanted to say at the beginning is that the Human Rights Act emerges in lots of ways from Northern Ireland. You know, the key impetus for its introduction comes from Northern Ireland, and that in that sense, it's very much you know, a UK product in Northern Ireland, and Ireland's product of its politics, of its history. It's not something foreign, and even if it is something foreign, I don't necessarily think that makes it bad per se. Whereas a lot of the discourse around this is sort of about the foreignness of it, but the necessity and the need from it really came from UK and Northern Ireland specifically, politics and history. And because it emerged from Northern Ireland, the way that the Human Rights Act was shaped, the quality of the rights protection that now, of course, across the UK and as regards to Ireland, because it impacted on law in the Republic as well, it's firmly embedded in it, the shape of it. And you can even see that in Brexit, because I think Brexit is not unrelated, but the Northern Ireland Protocol under Article 2 of the Northern Ireland Protocol specifically talks about the 1998 agreement, the Good Friday Agreement, and what it refers to as non-diminutive rights. So the idea that you can't go back on the rights that are covered by the protocol. So it is a very complicated set of structures, and which is very common in Northern Ireland, but it is very much you know, a product of the history and the politics. Now, the 1998 agreement has some very specific requirements. You know, it's very clear. It says that the British government shall incorporate into Northern Ireland law the European Convention on Human Rights, that there will be direct access to the courts, and that's very important for what's been brought forward, and also that there will be remedies for breach of the convention available, and as well that there will be powers for the courts in Northern Ireland to overrule assembly legislation coming out of Northern Ireland on grounds of inconsistency. And this is within the safeguards strands of the Good Friday Agreement. And you know, we have here specific reference to the European Convention, but there's also, you know, reference to some, you know, unfinished parts of it. So something like the Bill of Rights for Northern Ireland, and there was supposed to be a Charter of Rights for the island as well, which is supposed to supplement it, right? So that you not only would have the ECHR, but you would have a much broader, expansive set of rights in Northern Ireland as well. And this went on to include bodies like the Human Rights Commission in Northern Ireland, which does excellent work, looking at legislation coming out of the Assembly, out of Parliament, reviewing it for compliance with the ECHR. So in reality, it's sort of an ECHR plus model that's required in Northern Ireland. It's very much a floor and not a ceiling. So it's supposed to be ECHR and then everything beyond that. So I'll come back and talk a little bit later, but there's talks in the government about the idea of some rights being fundamental and then other rights not, and that runs contrary to this sort of ECHR plus model. It also required, as I mentioned, the Republic to bring in law that bring in the equivalent protection of rights. And when the Irish government were introducing that, they referred directly to the Human Rights Act of the UK and said that that was the model they were following in order to comply with their obligations under the 1998 agreement, because there is supposed to be equivalence of rights on the island. And that while that obligation lies with Dublin, it lies with the Irish government. There is supposed to be on the island this equivalent reciprocal set of rights, that everyone has this base and are supposed to be moving upwards. And you can see that again, as I say, in the Northern Ireland Protocol. Now, and it's important in that context, you know, the 1998 agreement is an international treaty as well as a domestic constitutional agreement. It is both things at once, and that's not that uncommon. If you look at peace settlements all over the world, actually, that's a very common model. Look at work. So it's not that makes it unusual, but it does mean that you have obligations going lots of different directions. And it is imperfect. Okay, the 1998 agreement isn't perfect. It has been changed. It has evolved since then, but it is the basis of a peaceful and democratic society in Northern Ireland that is reinforced by human rights, because the absence of human rights was an important contributor to the conflict in Northern Ireland, that people felt that their rights weren't being vindicated, that they could not access them, that the courts weren't open to them. There were cases, of course, between Ireland and the UK involving the ECHR. But these rights have been, you know, it's an important part of that the ongoing resolution of the conflict. And it has been, reiterated. So you get the St. Andrews Agreement talks about the ECHR and human rights. The Stormont House Agreement did a new decade, new approach, which is, very recent. Also, again, talked about rights, and we started a process for a Bill of Rights in Northern Ireland, but that still hasn't come to fruition. So I think it is important to think about the positive impact that the HRA has had in Northern Ireland, that there have been, shortfalls, but that it has helped address some of the legacy issues. For instance, it has, I think, allowed for a lot more buy-in to things like the police in Northern Ireland and the court system, and it is an important part of that infrastructure. Now, before kind of going specifically into this issues that are specific to Northern Ireland, I think there are broader issues that are also of relevance to Northern Ireland. And one interesting kind of side factor in this, to do with UK constitutional law, is that the Conservative Party manifesto pledges to update the Human Rights Act. It doesn't say anything about repealing and replacing it. And that actually will make it more difficult for the UK government, unless, of course, they go and have another election, as Brian has already referred to. Because it gives the House of Lords, for example, more opportunity to slow down any process of reform. And actually that is lesser than previous Conservative manifestos under David Cameron, which were very explicitly about replacing it. So there has been a dialing back in the language there. There is also sort of within it kind of as I mentioned earlier, a distaste for foreignness of law. So the government seemed to have a problem with the UK domestic courts looking at the European Court of Human Rights as the primary reference point within the infrastructure for interpretation. Now, of course, the UK courts do look to the European Court of Human Rights. They also look to a huge array of other sources. They look at other domestic cases, they look at cases in other jurisdictions. It is not that they only, but there is, and you see this a lot actually in blowbacks against international human rights, not just in the UK, but the sort of idea that the primary reference point within that structure. So for the European Convention of Human Rights, the primary interpreter of that is the European Court, but sort of a distrust of that, even though that's a very important, having that one body that gives a coherent understanding. But the characterization of kind of an over-reliance by the UK domestic courts, and you get a lot of mixed messages in this context as well, because on the one hand, the UK government are saying the judges are going too far in lots of areas like judicial review. On the other hand, they want them to be more active, but more active in not looking at towards Strasbourg for more cases. So you have this sort of contradictory view of a hyperactive judiciary, but they want them to be hyperactive, just hyperactive in a very, very different way. One of the other general points that's coming up is if within the proposals is the right to a jury trial. Now that doesn't exist in Northern Ireland. But why I wanted to raise it was that it specifically says, insofar as trial by jury is prescribed by law in each jurisdiction. And if you look at Brexit, one of the big issues that has especially for the members of the unionist community, is differentiation between the law in Northern Ireland and the law in England, Scotland, and Wales. And that's been an ongoing and continuous one. And it is obviously a hangover from the Troubles, but there is this sort of, it is this one area where the UK government seems to realise in trial by jury that there should be a differentiation, when in fact, perhaps it's the one area, trial by jury, where the law in Northern Ireland could be revisited. So it's an interesting moment where they could actually go further in human rights protections, and instead just sort of decide they're going to leave the devolved institutions. But I want to raise a broader issue about the amount of constitutional change and human rights change that is being introduced by the UK government at the moment. Issues around freedom of expression, journalist rights. If you look at the internal market bill and the way that that's impacted on the powers that the various devolved governments have, on the right to protest, on electoral reform. Now, all of these are broader UK-wide issues, but they also have a very specific impact on Northern Ireland. And I think need to be, I think it's important to look at those specific Northern Ireland things, but also there needs to be, impact of those broader changes that are being introduced, and I think are as an attempt to change the culture around rights in the UK. Now, as regards to Northern Ireland specifically in the Act, now there's lots of sort of individual bits that are important, but one of the specific elements, I think, is the relationship between the Northern Ireland Act itself and devolution and the Human Rights Act. So there are obligations under the devolution legislation that the devolved institutions that are directly connected to ECHR rights, you know, they must be compliant with the ECHR under the Northern Ireland Act and with the Human Rights Act, and that would require a change to the Northern Ireland Act. If they were to change the Human Rights Act in the manner that they are talking about, that would also require a change to the Northern Ireland Act, which would then require a legislative consent motion to be passed. And I think that's I think there is likely, if the Assembly is operational, of course, that there would be likely that would not pass. You also may potentially have a petition of concern, particularly from the nationalist parties, but also I would imagine from the Alliance Party. So there is mechanisms within Northern Ireland to try to halt or stall it, but there is within that context a very specific relationship between the way that devolution operates and the Human Rights Act, which hasn't really been given much importance. One of the other, I think, elements that are significant or should be thought about a bit more by the government is this idea of frivolous or spurious cases. And I think this runs into what Brian was talking about as well, about the legacy cases. The idea that some cases are just brought to be troublesome, and that they're going to bring up, or they're going to stop those cases. And of course, what London thinks is spurious and what London thinks is problematic is, you know, is contextually important. It might not seem so spurious if you're in Northern Ireland, if you're dealing with something coming out of Northern Ireland, especially if it is something to do with legacy, but wider concerns as well. But that is also impacting the access to the courts. And there's already, I mean, the European Court itself already has cut down on access to the courts through inadmissibility. And that tool is already problematic in the system. So this would be putting even more barriers in, which runs directly counter to what's in the 1998 agreement. And I've already mentioned a differentiation between fundamental rights and other rights. And again, this is particularly because the 1988 agreement sees the rights that are in the ECHR as a floor. So if, you know, there could be a Bill of Rights in Northern Ireland that might ameliorate this somewhat, but there is a very specific idea that it's that you go further than those rights, that the ECHR in and itself doesn't even cover the fundamental rights. The Human Rights Act doesn't even cover fundamental rights, that there are more rights than that. But the proposals point the opposite direction, that it's going to be narrowed, probably closer to some sort of idea of civil liberties in the UK generally. Now, having said all that, it is possible to amend the Human Rights Act, right? You could introduce a Bill of Rights that is entirely in line with the 1998 agreement, but that would be a positive Bill of Rights that extends rights, that supplements them, that goes for that ECHR plus model. And that's certainly not what's on the cards here. That's not what the current proposals suggest or do. And I think before any changes have to be done, the people of Northern Ireland, as they are called in the Good Friday Agreement, and the Irish government both have to be fully consulted, because it is both that international treaty as well as a constitutional document, right? Both of those groups, I mean, there's an international legal obligation under the Vienna Convention of the Law of Treaties that if you're going to change your obligations, that you consult with the other government. Now, we have, as regards to Brexit, seen the UK government's willingness to interpret international law as allowing you to unilaterally change your obligations. Now, that is absolutely not in compliance with international law at all. I haven't seen any international lawyer that has agreed with their stance on that. But there is absolute need for consultation, because frankly, we have seen what has happened with Brexit. We saw what happened when things were attempted. Northern Ireland, and you know, people in Northern Ireland, commentators, were saying this from the outset, as soon as you know, this was the referendum was mooted, that there needed to be a lot of thought given. And of course, this is partially why we've ended up where we've ended up today with regard to Brexit. consideration also needs to be given to the outcomes if there were an alteration, what that would happen, what outcome that would have for Northern Ireland, and I mean the broader political system in Northern Ireland. So much of the 1998 agreement was built on having a human rights infrastructure. If you remove that infrastructure, you will have a destabilizing effect. And the Assembly is already not running, the protocol and Brexit are already having a negative impact on the governance infrastructure in Northern Ireland, and this would further harm that. So there is a broader structural question, I think, beyond the actual details of what's going on. One solution would possibly be to have a Northern Ireland specific law that you would have. There is the Buckley Bill of Rights. That's the new decade, new approach. Did release a report, but that was stalled. We're not really any closer to a Northern Ireland Bill of Rights. You potentially could do that, but if Northern Ireland does it, I would imagine Scotland and Wales would also look to have a similar breakup. And what you might end up with then is sort of an England Bill of Rights, which I suppose you could have, but that raises a broader constitutional question, especially for England and Wales, where that law is much more entwined than in Scotland and Northern Ireland. But it is theoretically possible to do, but that is nowhere near where the British government are at the moment. That isn't even on the cards. It's not been suggested by anybody, so I can't see it happening. Also, would have to go through likely to go through the Assembly, and we would run into the same issues that previous iterations of the Bill of Rights have run into. You could also, of course, alter the Good Friday Agreement, but there you would have to get the Irish government on board, which, given what's happened with Brexit, again, it's entirely possible, but politically is going to be extremely difficult, given, I think, the distrust between the current UK government and the Irish government. Though again, I think likely the US administration and Congress could potentially help there. So I shall leave it there.
Great. So I am taking over from Jacob. Let me introduce myself. I am the person originally slated to chair today, and belatedly welcome everyone to the event. And thank you, Aoife, just now for your marvelous overview. And thanks as well to Brian previously. My name's Martin Flaherty. I am the Leitner Family Professor of Human Rights at Fordham Law School and the founding co-director of the Leitner Center for International Law and Justice, and a visiting professor at the School of Public and International Affairs at Princeton. And I've been involved in Northern Ireland matters for really since 1986, the year famously Ulster said no to the original Anglo-Irish agreement. And I apologize to everyone. Very uncharacteristically, I had all sorts of Wi-Fi problems, which were apparently related to construction nearby my office, but they were sorted out, and I'm happy to be here for the remaining part of the program. And toward that, and I also would like to thank Jacob for filling in for me unexpectedly under these circumstances. So since I am taking up the baton once again, or as originally slated, let me turn to my duties. And our final speaker is Nazia Latif. Nazia is currently runs rights practice and specializes in providing practical assistance to organizations in public, private, and voluntary sector to initiate, manage, and change in order to improve the lives of communities in Northern Ireland in particular. She is a graduate of Queen's University Belfast, holds an MA from the University of Durham and a PhD from the University of Newcastle on Tyne, and has extensive experience in working on human rights and equality issues in Northern Ireland and internationally. So Nazia, let me turn things over to you.
Thanks very much, Martin, and thank you to Rights and Security International for asking me to speak today about the role of human rights in the Good Friday Agreement. So I'm going to go back in time a little from what Brian and Aoife and Jacob have been talking about, and looking at the role that human rights played back in the Good Friday Agreement over 2 decades ago. So I remember asking one expert what he thought was the biggest achievement of the Good Friday Agreement, and he answered while it stopped us from killing each other. And well, I would say that that's no small achievement given what we know about the violent history of Northern Ireland. But I would say that the Good Friday Agreement did more than that. It gave us avenues for redress. It gave us a sense that we could trust those avenues, and in many cases it has delivered results. And I would say what it did, and it did that by giving the place it did to human rights law. You will all know that shocking human rights abuses had taken place in Northern Ireland when the Good Friday Agreement was being negotiated. You'll be familiar with the events of Bloody Sunday, the whole concept of indefinite detention without charge, or internment as it was known, and they're just two examples. And I wanted to give you a quote from Jane Winters. Jane Winters was executive director of British Irish Rights Watch, which was Rights and Security International in a former life. And Jane warned back in 1995 against the consequences of omitting human rights from any peace process or allowing them to be used as bargaining counters. And she argued that human rights violations, the imposition of emergency laws, and institutionalized discrimination against Catholics had fueled and prolonged the conflict for over 25 years. And so when it came to the peace negotiations, the British government promised to complete incorporation of the European Convention on Human Rights into Northern Ireland's law. And this has been quoted by Jacob and Aoife from the text of the Good Friday Agreement. So it would be incorporation with direct access to the courts and remedies for breaches of the convention, including power for the courts to overrule assembly legislation on grounds of inconsistency. And the Irish government also promised to examine the incorporation of the convention into Ireland's law, which it did in 2003. And as Aoife has said very eloquently, not only that, but we were also given the hope of further human rights protections through a Bill of Rights for Northern Ireland. So a Bill of Rights that would include rights supplementary to the European Convention and that reflected the particular circumstances of Northern Ireland. And I'll return to that a bit later. What was important about the Good Friday Agreement, that it wasn't a vague commitment. It was a lot more than platitudes to protect the human rights of all. It was followed by legislation that gave domestic effect to a regional human rights treaty. And the Human Rights Act, in many respects, is the closest thing, I would say, that not just Northern Ireland in terms of in the Good Friday Agreement, but it's the closest thing that the UK has to a written constitution. All legislation and policy must be compatible with the Human Rights Act. And the Human Rights Act then is fundamental to the international peace agreement that is the Good Friday Agreement. The British government essentially promised to bring rights home, and in many respects they did. Now, the experience of individuals as they have gone through the courts or other statutory agencies has by no means been perfect. But the system of human rights protection in Northern Ireland is currently a relatively good one. So I wanted to ask the question, well, what changed as a result of the centrality of human rights, the Good Friday Agreement and incorporation of the convention? What change did it actually bring to people in their everyday lives? Because this is more than a legal or an intellectual exercise in trying to hold on to a piece of legislation just because it's there. And I'm going to look at the example of policing, because I think policing is undoubtedly one of the big successes in Northern Ireland's peace process. In fact, to the point that American colleagues wondered if an independent review of policing and the way that we had the Patent Commission was needed for policing in the States in the wake of George Floyd's murder and subsequent protests there. But that's not to say that much more doesn't need to be done. And sometimes those of us that live here in Northern Ireland feel that we're going backwards. But nonetheless, it can't be denied that the Human Rights Act fundamentally changed policing for the better in Northern Ireland. And so how did it do that? Well, the first step was admission that things needed to change root and branch. It had to be more than cosmetics. There had to be a new beginning. And that new beginning was human rights law, and it was specifically the Human Rights Act. So the report of the Patent Commission, which was set up as a result of the Good Friday Agreement to look at the future of policing in Northern Ireland, concluded in its report that it is a central proposition of this report that the fundamental purpose of policing should be, in the words of the agreement, the protection and vindication of the human rights of all. And I don't think that we can disagree with that. But in Northern Ireland, as we have seen elsewhere, it was the police that were responsible for many of the human rights abuses. So their role was not just to protect us all from non-state actors, but in many respects from themselves. And the Human Rights Act put the parameters in place to allow what we call here now in Northern Ireland a human rights-based approach to policing, to the point that 3 separate chief constables have welcomed the introduction of the Human Rights Act, because they say it provides them with those parameters, with that framework for decision making. So when and how can they interfere with someone's right to privacy through the use of surveillance? When is the use of force justified? How should a public order situation be policed? The Human Rights Act has provided the framework for making those decisions. But just as importantly is that a human rights-based approach to policing has given the police service here legitimacy from all communities. Importantly, what the agreement did in its creation of structures was to use human rights as a tool for getting it right from the beginning. It wasn't just about providing recourse to the courts after the abuse had taken place. And this is where the policing board has a fundamentally important role to play. You know, I'm not trying to say here that the police always get it right. Problems occur, and we still have many real problems in terms of stop and search and the use of covert surveillance. But the police service's performance regarding human rights is very closely monitored by the policing board. And the policing board has a statutory duty to monitor their compliance with the Human Rights Act. It's agreed a human rights monitoring framework, which sets out the standards against which compliance will be assessed. And every year, a detailed report is issued on human rights, mostly drafted by the policing board's human rights advisor. And incidentally, the policing board's very first human rights advisor back in 2002 was Keir Starmer, the current leader of the opposition. And the PSNI, the police service here, also applies a code of ethics, which makes multiple references, not just actually to the European Convention, but to additional human rights standards that have been agreed at the UN. Essentially, the police service here has adopted a human rights-based approach to policing as a direct result of the Good Friday Agreement and the incorporation of the European Convention. The level of transparency required from the police here is significant. And as a result of this approach to policing, the service here now enjoys a very high level of support throughout Northern Ireland and even in Republican areas. And some commentators would say that this approach was in fact the only way the police would have enjoyed widespread support. So as the previous UN Special Rapporteur on Counterterrorism said, effective policing invariably involves and delivers human rights-based policing. And then the fundamental importance of human rights principles was further recognised through the introduction of affirmative action in recruitment to the police service, or what came to be known as 50-50 policing. So the controversy around that particular measure can't be overstated, but nonetheless, it was a policy in place until 2011. So peace in Northern Ireland really could not have been achieved without the commitment to human rights and without the legislation and the structures that cemented that commitment. But let's be clear, as Aoife has said, the Human Rights Act was only a start for many of those that were involved in those peace negotiations. So Monica McWilliams, for example, has said publicly that it was clear that a Bill of Rights for Northern Ireland wasn't an aspiration, it was a promise. And the Good Friday Agreement, it talks about the Northern Ireland Human Rights Commission being invited to consult and to advise on the scope for defining in Westminster legislation rights supplementary to those in the European Convention. And this is to reflect the particular circumstances of Northern Ireland, drawing as appropriate on international instruments and experience. These additional rights are to reflect the principles of mutual respect for the identity and ethos of both communities and parity of esteem, and taken together with the European Convention are to constitute a Bill of Rights for Northern Ireland. So as Aoife said, the incorporation of the European Convention was the floor, it was the bare minimum. It wasn't the ceiling. So Monica and many others would see the absence of a Bill of Rights as one of the key outstanding commitments of the Good Friday Agreement. But as well as these outstanding commitments, as well as this sense that there's a business still to be done, I have to say that there is a sense now that things are starting to unravel. We've heard about the threats to the Human Rights Act, which I would say is ultimately a breach of the Good Friday Agreement, and then the legacy proposals. And we don't have a sitting executive. There has been unrest in loyalist areas, and some loyalists have withdrawn their support for the Good Friday Agreement. There's nervousness and anxiety amongst community groups about what the summer months here will bring in terms of further unrest. And there's a sense that even the policing board is losing some of its hard-won authority. So is it a case that the Human Rights Act, or what the Human Rights Act could do for peace in Northern Ireland, was overplayed or overrated, or has it served its purpose and is it no longer necessary? Well, I would say actually that the commitment didn't go far enough. 50-50 policing, for example, ended too soon. There was an emphasis on recruitment, but not retention. We didn't get the Bill of Rights that would have addressed some of the legacy issues. We didn't get the effective investigations into deaths that we should have, and there's still outstanding cases with the European Court of Human Rights on that. And Brian mentioned Pat Finucane. We're still waiting for a proper Article 2 compliant inquiry into that. The government's legacy proposals and the plans to reform the Human Rights Act are having this chilling effect on duty bearers here, because when the commitment is no longer there from the top, the institutions that are mandated to hold those duty bearers to account are weakened, whatever the magnitude of their efforts to hold their ground. And I really want to emphasize the importance of human rights in a post-conflict context. We're over 20 years now from the Good Friday Agreement, but Northern Ireland is in a very precarious place, and the human rights that we secured in the Good Friday Agreement are under threat. It's not the case that those human rights are no longer necessary, but it is the case that those human rights have been under sustained assault for many years. And there has always been a faction that speaks of human rights here as if they're speaking about pie. So more for that community means less for us. And there is a real concerted need for human rights defenders to address that narrative and dispel some of those myths around human rights. And this idea that Aoife mentioned about frivolous claims to human rights and to dispel this. So really, in conclusion, I would reiterate everything that Jacob and Brian and Aoife have said in terms of calling the human rights community to come out and to support the extension of human rights protections in Northern Ireland and UK-wide, rather than the retrogression of them, which inevitably is what these latest proposals are going to lead to. So thank you.
Great. Thank you very much, Nazia. And apropos of what you said about possible lessons for the US, I put in the chat a little op-ed I wrote for the Washington Post on just that point. So I think it will echo many of the points you made. So we are going to turn now to question and answer. And the way we shall proceed would be, I would invite members of the audience, and I'm happy to say it's a good, healthy audience out there, to use the raise hand function. And I will keep the queue and recognize people and try to keep your questions and observations brief, although happily we do have, I think, a full half hour. And let me start with a little bit of a windup. When I first came to Belfast to do human rights work, it was with CAJ as an American intern. And one of the things I wrote was actually back in 1986, a Bill of Rights for Northern Ireland. And what the prospects of that would be well before the Good Friday Agreement. And one of the people I talked to about that was Pat Finucane. And as I understand, Brian indicated, although I was at that point having Wi-Fi problems, Finucane literally gave his life for the realization of the fundamental rights recognized in the European Convention on Human Rights. He brought several landmark cases from Northern Ireland to Strasbourg, and ultimately that led to his eventual assassination, it is fairly clear. Which brings me to my first question about legacy. Brandon Lewis, the Secretary of State for Northern Ireland, prior to the introduction of the current bill, assured everyone who had met with him, who was criticizing the command paper, that any proposed legislation would be Article 2 compliant with the European Convention. And I apologize, Brian, if you've gone into this in any detail, but I cannot think of anyone outside of government lawyers at Westminster who thinks it is Article 2 compliant. One thing, though, that has not been widely noted is precisely because it is not Article 2 compliant, doesn't this legislation, if passed, guarantee years, if not a decade, of litigation, first to the UK Supreme Court, and then ultimately to Strasbourg? And doesn't that utterly undermine the contention that this bill needs to be passed now so we can move forward and get on with it in Northern Ireland? So I think that's primarily to Brian, but I'm sure any of the panelists could handle that.
Thanks very much. Thanks, and hello, Martin. And I'll address one aspect of that briefly, because I'm not a lawyer, like full disclosure. And I think that some of those legal minds are better off addressing that. I would say from a political point of view, yes, that's true. I think it's a very cynical thing from the British government. I think that they're fully aware that's going to happen. But if their calculation is, this legislation might eventually succeed, or it might eventually not succeed, but it will take another decade, that's a big win for them. I mean, every year that goes past, every month that goes past, certainly every decade that goes past, makes it much easier for them to handle these issues, right? Any prospect of perpetrators being brought to justice recedes every year, just because of time and age and death, frankly. So yes, even if we manage to delay the implementation of this legislation, that's still a good thing for the British government. But I'll let some of the legal experts address the possible challenges to it and what that means legally.
Yeah, I can add something briefly. I see if you wanted to add, but I just on the Article 2 thing, I think you're right, Martin. There have been so many kind of legal analyses of both the prior command paper and subsequently the draft legislation. And I think reading through the Northern Ireland office's memorandum, so they have to prepare a memorandum to kind of explain why they believe that the legislation would comply with the European Convention on Human Rights. Kind of just from looking through that, you notice a number of possible inaccuracies. I say possible inaccuracies. I think it's quite clear that they've selectively chosen the law, shall we say. So I think that's pretty clear on the Article 2 front. And yeah, just to kind of expand a bit on what Brian mentioned about the delaying, I guess one thing to stress is that we've seen delays in these cases over years and years and years. And despite prior court pronouncements and sometimes prior political pronouncements that we will have certain investigations and things will progress in that manner, it's just not happened. So yeah, I would echo what Brian said on the delay.
Great. Any other views among the panelists?
I would just add that I think it's important to see it in the context of the Human Rights Act reforms and the order in which things happen on that front. But also I think that there is a specific tactic going on as well, generally about law and lawyers. That's also related to what Brian is saying, because if you look at what's happening with Rwandan deportations as well, like they're doing them, or they're trying to do them before the legislation is introduced, and almost baiting cases to happen, because that backs up their overall argument about it. And of course, that's for an English constituency. That's not actually, because the Conservative Party is an English political party, but I think you can see that across a range of legislation, not just the legacies bill, but sort of around immigration, around protest. You can see it as a specific tactic to try to discredit all lawyers, frankly, practicing and academic.
Right, indeed, including your colleague Colin Harvey on a different set of issues. And the only footnote I'd add is that the lack of Article 2 compliance is not simply a function of the European Court of Human Rights interpretation of Article 2, but actually a function of the UK Supreme Court's interpretation of Article 2, including and especially in the case about Patrick Finucane. which says that Article 2 has a set of rigorous requirements that a government must undertake for effective investigations, most of which are not going to be met in this bill. One of the organizations that has actually done a very good job critiquing both the command paper and current bill is the Bingham Center. And so our first question from the audience is from Ronan Cormacane from the Bingham Center. So let me throw things over to you.
Thank you very much, Martin, and I'm glad you appreciate our analysis of the bill. I've just posted a link for it. I should say, as well as being a lawyer in the Bingham Center for the Rule of Law, I also have the privilege of drafting legislation for the Northern Ireland Assembly. So 3 points about the Northern Ireland Troubles Bill. I'll be as brief as possible. It's an awful bill. The first point is, though, it's not just an amnesty from prosecution. It also nearly shuts down completely inquests, civil cases, and even complaints to the police ombudsman. So that's really access to justice on many fronts denied by the bill. The second appalling thing about it is, I know there's been a focus on victims of state violence, but the bill applies equally to victims of non-state actors. So I'm sure we can all think of lots of atrocities from Northern Ireland. All those victims, regardless of whether they're state forces or paramilitaries, they will all be denied justice by this bill. And the third point is on the very low hurdle for impunity under this bill. So all that is required is for the person who's seeking impunity to give, quote, an account which is true to the best of the person's knowledge and belief. So there's not even a requirement to actively engage or cooperate with the commission, or to give a full and frank account, or to exercise some sort of contrition or any exposure to the rights of victims. It's simply that the person only has to say, I did this crime, I want immunity. And that, in the text of the legislation, is all that is necessary. So yes, there's many things wrong with the bill, and hopefully it will be heavily amended, if not passed at all. Thanks.
Great, thank you very much. And yeah, I absolutely agree with you on your analysis on all those points. Our next question comes from Thomas.
Yeah, thank you. So one of the points that was raised by the DUP with regards to Brexit was that Northern Ireland had to be treated the same as other regions in the UK, but we've long deviated with regard to human rights in terms of reproductive rights. And also, in my opinion, I think there's an issue with regard to our licensing laws, where we're not allowed to buy a beer after, well, it used to be 1 a.m., now it's 2 a.m., but it still deviates from a lot of countries in Europe and the rest of the UK. And I think it's very unfortunate that it's gone on for so long, and it isn't considered an infringement upon our cultural rights or a right to a private life. So I just want to ask, does the panel perhaps conceive that that could be considered a violation of the right to a cultural life with regard to how we relate to other countries and their ability to enjoy it?
Does anyone of you want to handle that?
Well, I think it probably would depend on how it would be framed, because there would also, I mean, governments are entitled for health reasons, for instance, so you'd have minimum pricing being introduced in Scotland and in the Republic and stuff. So there is, the ability to regulate for public health is very broad and very wide. So there would be a balancing between the because as you say, there are lots of ways in which the law in Northern Ireland is different to the law in Britain, and indeed in Scotland and Wales. So there is a huge amount of deviation and around things like alcohol opening hours, but also around everything from agricultural products on. So it's there, but I would say specifically on that specific issue, that it would be the balancing between public health regulations and the government's ability to regulate there, and that for things like alcohol and tobacco and things like that is actually quite high. So it would be whether or not they had gone through whether or not the Assembly they go through a proper process of looking at it and analysing it and stuff like that. If that answers your question.
Good. So let me shift things away from the law to politics, both with regard to legacy legislation in particular, and this general turn away from the law, which is a term previously used by experts on China that seems to be going on at Westminster these days. And it's really what can be done to, if anything, to pressure the current government with regard first to a more effective legacy bill, and secondly, not to dismantle the constitutional or quasi-constitutional protections of the Human Rights Act. And so on the one hand, it's a high mountain to climb. The Tories have a comfortable majority. It seems that they are pandering first to the veterans community in England, and secondly, to a general hostility to government accountability, especially by independent courts, whether foreign or domestic. And that seems to be very much part of the whole ethos of Brexit and the return to making England great again. On the other hand, I think one reason there has been delay, at least in the legacy legislation, is the United States. In fact, I think the only effective player with regard to putting pressure on the UK government with regard to the Good Friday Agreement in particular is the United States. So is that right? Is the United States the main player when it comes to trying to prevent some of these developments? And what other sources of hope might there be to roll back both the legacy legislation and the proposed Bill of Rights for England, which is just the reverse?
I can start off with just a few thoughts of things that I touched on in my opener. I think one area is the trade angle, which I think has been much discussed, particularly around Brexit, and that's one area. The other thing to consider as well is, and I touched upon this earlier, is the universal periodic review process. So the UK is being reviewed by the UN Human Rights Mechanisms, I think October this year, somewhere later on this year. And I think that can be a helpful opportunity. So we've seen in the past other countries, I know the other governments, the US has, I think some other European and African countries in particular, their governments have made specific recommendations about transitional justice and legacy issues, and some more general recommendations about human rights reform. So we've seen it in the past. I guess the question is to what extent things are going to be listened to. I guess I'm partly optimistic that this time around these kinds of critiques will be listened to more frequently because of the as I say, the trade situation. But on the other hand, recent legislative developments almost give the impression that the current government, frankly, don't care. And so, yeah, I think there's more scope than usual, and I'm trying to be optimistic about it. That's just my few thoughts really on that.
Mm-hmm. So, other panelists on sources of hope and sources of points of pressure?
I did touch on some of that stuff briefly when I spoke mine. So I won't go through all that again, but I do think that locally too it matters a bit that the consensus, the pushback from civil society and from the political scene in Northern Ireland against the original command paper did force some changes, right? Like not enough, and the thing needs to be scrapped, but that was listened to at some level. I think apart from the US, I don't see many other players. I think the UPR thing is worth pressing because I do think that it's a bit embarrassing and it's easy to do. And I'd urge people, NGOs, to make submissions under the UPR. It's pretty easy form to fill in, and you can have those issues raised. But I don't really think that, however embarrassed the British government would be at UPR, it would stop or amend this legislation. And that really does leave it either, as I say, if there's actually an early-ish election in Britain, I think that's possible. And there might be a change of government. I think that's also, within the realm of possibility. I think the bad news on this is, as we've seen, and certainly seen in the US, that the courts really are ultimately, and the independence of the judiciary is ultimately at the mercy of politics. And certainly that's happening in Britain too. I think the good news, if you like, is that certainly the English public is sort of unaware of, or pretty agnostic about this. There are some groups, like the veterans groups, are pretty well organized. But this isn't something which a political party is going to win or lose a general election on. I mean, most voters in England either just don't know or just don't care enough about what happens, which is a tragedy in itself. But nonetheless, it's not going to be something that necessarily the opposition parties are going to feel railroaded into support in the way that they have been or let themselves be on issues around immigration, for instance. So I don't think it's all over. I think that a Biden administration can put a bit of a spanner in the works for the British government over trade. I'm very fearful about, I'm sure many of you are, about what's going to happen in 2024 and all the repercussions of that if it goes wrongly, not least for this process too. So yeah, I don't think all is lost. I think there are some things we can do, but I do think that the outlook is fairly bleak.
And Aoife and Nazia, do you have any thoughts?
The one thing I would say maybe on the European front, on the European Court of Human Rights, is that what might actually help is Russia and Russia leaving, and Russia, the Council of Europe, and leaving the convention and leaving is, you don't want to look like you're on the same, particularly politically for the United Kingdom. So that sort of, the sort of, if Russia feels the need to leave and Russia thinks it's bad, you don't want to be on the same side as Russia at the moment on anything, on any front. So in lots of ways that, in a way that the war is absolutely obviously horrendous and awful, but Russia's sort of dislike of the convention and disentitlement, I think it was waiting for an opportunity to leave as well, frankly. But that in some ways helps the kind of legitimacy of the Council of Europe more generally, because it's, leaving it is the thing that Russia does, and nobody wants to do the thing that Russia does.
And could I just follow up there, which is, and I'd be remiss, because Brian and I have worked both on Northern Ireland and Hong Kong. Would you comment on the diametrically opposed positions that the UK has about international law with regard to Hong Kong as opposed to Northern Ireland? And have you posed that in any of your advocacy?
Me? Are you asking me?
Yeah, I'm asking you, Brian.
Yeah, absolutely.
You work in both jurisdictions.
I mean, I find the British government, and also I have to say the US government, where I probably do most of my advocacy, wonderfully contradictory and hypocritical. I can go and argue fairly persuasively at the State Department about how they should pressure other governments to end the death penalty. And, there's seemingly no contradiction there among American government officials who think that that's a great idea, despite what's happened in the US. And on Hong Kong too, I mean, it's clearly, cynically, totally selective, right? The UK wants to stand up for human rights and the rule of law and all that other platitudinal stuff in the places it wants to, and in the places it doesn't want to, which isn't just at home. It's not that bothered about what's happening in Saudi Arabia either, because of political allyship. So I wish it were more embarrassing for them. And it's sort of not. I don't know that they're actually shameless, but these paradoxes, contradictions just don't really seem to be enough to make them change their mind. You can win I find you can win an argument or embarrass someone on a sort of a one-to-one personal legal argument, but that isn't the force that it takes to change the legislation.
Thanks, Brian. And Nazia, you didn't get a chance to weigh in on points of hope or pressure points or advocacy. So I'm wondering if you had any thoughts.
Yeah, I mean, I'm trying really hard not to sound not to sound like I'm despairing of the situation, but there certainly is a sense of that here in Northern Ireland, and I think UK wide. I think your point, I mean, I think there's two issues that are going to impact on what this government does. One is negative economic consequences, because they are desperate to show that Brexit it has been a success, which we all know otherwise. And the other thing is what's going to win them the next election. And unfortunately, what Brian is saying is that this isn't going to win or lose them the next election. So that does leave us back with the US. And the US, of course, was fundamental in negotiating the peace agreement here. So it's not just that there's hope there, but I think there's also responsibility on the US to, the broker the agreement, to make sure that the agreement stays in place. But I think those points about Russia and Hong Kong, I think we as a human rights community and as a group of human rights organizations need to articulate the message better. Why is it that a government can come along 2 decades after incorporation of the convention and say, no, we're not going to do that anymore? Something's gone wrong. And I think there's a real need here for some sort of internal analysis of, well, what do we need to do as human rights organizations? Because there's certainly been something lost in the messaging up till now.
Mm-hmm. Good, thank you. And two follow-ups. One is I noticed that Ronan had posted another great critique of the legislation, largely from the Queen's University Belfast faculty and the Committee on the Administration of Justice in the form of something called the Model Bill Team. And so that is also worth looking at for those of you interested in this issue. I also have a question in the chat, which is that the previous Northern Ireland Secretary, Julian Smith, actually has departed or never joined the kind of current UK establishment view with regard to this drift away from law, and slammed the bill and also slammed the command paper. And the question is there any, or could there be any correlation between that point of view in the Tory party and those who voted for no confidence in Boris Johnson? I don't see much of a correlation, but then again, I'm not a close analyst of British politics, so let me toss that one out. I guess the question is there any interest in the backbenchers, in any of these issues?
I think one thing, I guess I would say likely not. I guess there is, in a way, to an extent, that many of the backbenchers will be supportive of any of the government's legislation. One thing as well to consider is that particularly backbenchers, there are a lot of them, particularly military constituencies where there's army camps, for instance, or other installations, and they will tend to fall on the side of veterans and veterans affairs, and therefore will generally be in support of this bill. I guess I can see a bit of correlation in that some of the more long-standing MPs, so some of those with more direct experience will be also the ones that are more likely to be outspoken. But I think beyond that, I don't see anything. I don't. But any of the others might have a different opinion than me.
Right. Good. Well, I think we have enough time in the few minutes remaining for any closing thoughts by our panelists. And then I will close with an idea or two about what Americans can do with regard to these issues. So let me throw things open to any final thoughts from any of the members of our panel today. We could go in order. I'll put you on the spot first, Brian. Any final thoughts? And then,
all right. In fact, and not to preempt what you might be saying, but my focus in a lot of this is what the US can do, and it's not just the US government, right? I think there are other actors in the US who have some influence here, and if we look at a recent the attacks on Colin Harvey, the solidarity that he got from various places in the world, were, he tells me, enormously important and helpful to him, not least from the US and not least from I think the Dean of Fordham, I'm not sure if the bar councils did, but those sorts of things, you know, you really can help local human rights defenders, local human rights lawyers who are really going to be up against it, right, in the coming years. However this plays out, like their lives are going to get very tough, and they are going to feel, and some already do, I mean, literally, you know, threatened, right? So, you know, if you are one of the US based in the audience here, then, you know, of course, try to use whatever political connections you've got, but don't underestimate the importance of, say, academic or even business connections that you have too. I think that matters.
Thank you, Brian. And Aoife, Nazia, yeah.
I suppose what I would say, and I think, is that it's important also to see this in the context of what's happening to British politics, much as what's happening to American politics, and the way that, you know, things become part of the culture wars. There's an othering going on, that groups are problems, that groups are not allowing things to progress. Northern Ireland is holding back Brexit, Northern Ireland is holding back human rights reform. But that's replicated with other questions, and I think there is and I'm sure others here are very, very aware of what I think is a very negative trajectory across the UK Constitution that this forms part of, that is in lots of ways actually quite terrifying if you put them all together. And I think it's incumbent on everybody to get involved across the issues. And I think there can be alliances there in Northern Ireland with Scotland in particular, and with Wales, and, you know, since its own devolution has, I think, probably gone further in that it started at the lightest and has, you know, pushed itself very far, especially on human rights and bringing in children's rights, etc. So I think that there are alliances there to be built with the devolved administrations and the devolved the MPs from those areas as well, because a lot of the push to dismantle human rights infrastructure and constitutional infrastructure is coming from England and English MPs. And I think it's important, not all, of course, some of them are very good at trying to stand up for it and have made very good speeches, I think, in Parliament and in the House of Lords, which I'm not in favour of unelected bodies, but the House of Lords has also done some very good work on this. But I think it's important that those sort of alliances are built amongst groups that you know, can see the broader constitutional problems that will have ramifications for Northern Ireland, but across the United Kingdom as well.
Great. Nazia?
I mean, I think the main point that needs to be gotten across with both the legacy proposals and the Human Rights Act reform is that really they're pretending to fix a problem that doesn't actually exist, particularly in terms of the Human Rights Act, you know, and to use that sort of very famous American phrase now, you know, this idea of fake news. I mean, you know, all these made up problems about what the Human Rights Act has created and what it's done, and these, you know, ridiculous claims about not being deported because you own a cat, and, you know, things that have been going on and rumbling on for many, many years here. And similarly with the legacy proposals, this idea that is, you know, that we have tried our utmost best to bring truth and justice, when the truth is that they haven't invested anywhere near enough resources into you know, into truth and recovery in Northern Ireland. That the Ministry of Defence has nowhere near been as transparent and as open and forthcoming with information that it has needed to be. And so I think that really is a key message, and that, you know, it is really sort of dispelling some of those myths about where we are. You know, to me, really, the simple message is there isn't a problem here that you're claiming needs to be fixed with these reforms.
Great, thank you. And Jacob, did you have any concluding thoughts?
Well, I think most of it's been covered. I guess the one thing I really think should be stressed is putting this in the context of, you know, the continuous delays, particularly when it comes to legacy investigations that have occurred over the past 20 or so years. And I think once seen in that context, I think there is really, you know, only one way to go about engaging with legislative changes, and that's to ensure that everyone can have access to justice that they've been missing out for so long.
Great. Well, thank you all. My final thoughts really will, in one sense, just echo Brian's with the additional point that one of the very, very few things in terms of US policy that remain bipartisan are issues like this on Northern Ireland. It's one of the few areas where you have members of Congress on both sides of the aisle concerned about these issues. And I think that reflects a sort of broader unity on these issues with regard to Northern Ireland that involve not just the Irish American diaspora, but go beyond it. And so with that in mind, I think those of you who are concerned about these issues, first of all, should, as always, educate yourselves further using some of the documents that were made accessible today. But also contact your representatives. If you are in business, think about ways your business enterprises can weigh in. Certainly, many of you out there are involved with NGOs. That is also a pressure point, including especially the New York City Bar, which I think will remain seized of this issue and continue to take a leading advocacy role. So I hope, as in most things we do here at the City Bar, this is not just to have a conversation, but that the conversation leads to action. So with that in mind, I'd just like to finish by once again thanking everyone involved in putting this together, including and especially the Council on International Affairs, Mark Meyer, Chair, the European Affairs Committee, Jonathan Halpern, Chair, but most of all, the Committee on International Human Rights, Ramya Kudakalu, Chair, as well as former Chair Lauren Melkis, and Jacob Smith of Rights and Security International, who was really instrumental in keeping this going and getting it going. And I hope this association continues. So thank you, everyone. And we will do our best here at the City Bar to keep everyone posted on developments. So thank you all.
Thank you.
Bye-bye.
Thank you.
Thanks very much, Martin. Thanks everybody for organising. Thanks,
you.
Jacob.